My name is Dr. Juliet Chevalier-Watt. I'm one of the lecturers here at Piringa Faculty of Law, and I'm really hoping that everybody in Zoom can hear me as well. So I'd be very grateful if somebody could just give me a thumbs up if they could hear. So what I'm going to do now, before I do anything else, is I'm going to hand over to my colleague, Dr. Robert Joseph, who is going to do a mihi. Thank you.
Tēnā koutou katoa e te whānau I taimai nei raro I te tāhuru o tēnei whare, te whare wānanga o Waikato. Kanu te mihi atu ki a koutou katoa, he mihi ki te atua, e whakakorore a tōnei ngoa, he mihi ki te kini Maori a tūheitia, a potatau te wherowhero te tuawhitu. E noho mai rā I rungi te ahu rewa tapu o ona mātua tupuna, kei te mihi ki ai o te rā me tōna whare kāhui a riki nui tonu, a rire hau, pai marire ki a rātau, pai marire ki a tātau. Enga mate ngai tau tātau, haere atu koutou, enga hunga ora, tēnā koutou. Tēnā koutou katoa I ngā rangatira o ngā hau e whā, ka nui te mihi ki a koutou, ka nui te hara, ka nui te hariko tai mai koutou ki wainganui a mātou, ki tēnei kaupapa I tēnei rā. Ko te kaupapa pērā nei, ki te whiti kōrero, te kaupapa o te ture o te ao katoa. Ara te Beeby. The Beeby Exchange on International Law Waikato, a discussion of topic issues. He kaupapa whakahirihira, he kaupapa pai. No reira, rauranga tira mā, e hoa mā, nau mai hara mai, nau mai piki mai, kake mai, haere mai, ki tēnei kaupapa. Ka nui te hariko tai mai korua, rangatira o te mana tū aurere, Ministry for Foreign Affairs and Trade, nau mai hara mai, nau mai piki mai, kake mai, kōrero mai, ki tēnei kaupapa. O te rā, e raurangatira mā o ngā hau e whā. Ka nui te hari, kuhu mai ki tō tātou whare, te whare wānanga o Waikato ki tēnei kaupapa. No reira, raurangatira mā, tēnā koutou, urinoa, tēnā koutou katoa. Ka pae here tia korua kia kotahi ko te whakapono he kakahu ko te ture he whariki. Ka mau ki te aroha ki te ture me te whakapono nā po tato te kōrero tohu to I tuku nā iho mai kia pai ai e noho. Anga iwi e kōpiri. Apiti ono tātai hono te hunga mate ki te hunga mate, apiti hono tātai hono te hunga ora ki te hunga ora. Tātou ki a tātou, rātou ki a rātou, tēnā koutou, tēnā koutou.
Thank you very much for that, Robert. So, on to my more fulsome welcome to explain who we are and what we're all doing here. As I said, my name is Juliet Chevalier-Watt, and I, along with my colleague and co-host, Dr. Alberto Alvarez-Jimenez, we are the directors of the Waikato Public Law and Policy Unit at the Piringa Faculty of Law. And we are delighted to be hosting the Ministry of Foreign Affairs and Trade for the Beeby Exchange on international law, and I will introduce our speakers very shortly with regard to that. So I just wanted to give a quick rundown of what's going to happen with this particular session today, just so you understand. I will shortly introduce our very first speaker, and then So we'll talk for 10-15 minutes, something like that. And then what we will do is we'll open up the floor for questions. So that will be questions either from those in the room or those on Zoom. For those on Zoom, if you want to ask questions, and I really do encourage you to ask questions wherever you are, you can either do it by raising your hand, or you can do it via the chat function. I'll be monitoring that as best I can. And obviously, if you're in the room, raise your hand or speak up, whichever, don't mind. So I'll be monitoring them to do that. And then there will be a wee break for refreshments. So if you're on Zoom, you can vanish off, go and get yourselves a cup of tea or coffee. And then when we come back, there'll be a couple more speakers, again, questions and answers, and so it goes on until our final speaker this afternoon. So without further ado, I would like to welcome up here Sarah Ireland, who is from MFAT, and let me just quickly find Sarah's details. So Sarah has worked for Ministry of Foreign Affairs for 15 years, 5 of those in the legal division, and recently in the General International Law team, which essentially is everything other than trade law, environment, resource law, but with particular focus on security issues. She was posted to the New Zealand High Commission in Canada and had roles in the ministry's trade negotiations, Southeast Asia and Pacific regional teams. And she was also New Zealand's lead negotiator for the Trade and Services Agreement and lead counsel for the Comprehensive and Progressive Agreement for the Trans-Pacific Partnership, not TTP. So on that note, I shall welcome Sarah up here, please. Thank you very much.
It's wonderful to be here. It's my first time at Waikato University, and it's, I think, our very first Beeby Local event. Normally, as you know, the ministry tends to hold one in Wellington, but it's really wonderful to be able to come out and visit your house as well today. So today, I'm going to focus on 2 areas. Part of the Beeby is to talk about things that you've been working on, and 2 areas that we've been working on in the general international law space relate to Russia's invasion of Ukraine. So the first thing I'm going to talk about is sanctions, and the second thing I'm going to talk about is the Ukraine-Russian Federation case for the IC, the International Court of Justice. So actually I'll just take my mask off. Russia's aggression against Ukraine poses the biggest challenge to the current rules-based international order, we think, since the Charter was established in 1945. Having a permanent member of the Security Council pursue an illegal war of aggression in the face of widespread international condemnation poses a fundamental challenge to the effectiveness and legitimacy of the United Nations and its institutions. If left unchecked, Russia's actions could cause lasting damage to the foundational rules of peace and security, and that is why New Zealand considered it was really important for us to act. As the Prime Minister has said, Russia's actions are an affront to all of us, not because this conflict should be characterised as a war of the West versus Russia, or even democracy versus autocracy. It is neither. Rather, it is a war of Russia versus all those who hold a basic sense of humanity and choose to act on it. So the first thing I'm going to talk about is sanctions, and I'm starting there because one of the things that happened to me this year is after the Russian invasion of Ukraine, we essentially had to develop essentially a new government function in relation to sanctions to Russia, and one of my roles was being transitioned into what we call the Russia Sanctions Task Force, which is an interagency task force that manages that process. So, as many of you know, sanctions are basically coercive measures that can be applied to diplomatic, economic and cultural relations between states. The purpose is to encourage or incentivize, condemn or encourage or incentivize a change in behaviour. Now, prior to the Russia Sanctions Act, which was passed under urgency in Parliament in March this year, The New Zealand government only had the power to impose sanctions under the United Nations Act 1946. And it could only do that if they were authorised by the United Nations Security Council. And to be honest, that remains the government's preference. We prefer to act consistently with rules decided at the international level. And we also think that sanctions work best when they are undertaken by the broadest possible range of countries. And of course, having the UN Security Council and all states being required to comply with the directions of the UN Security Council ensures that happens. But because Russia, as we all know, is a permanent member of the United Nations Security Council, it is able to veto UN security action in this case. So that left us with a little bit of a quandary. What do we do? It doesn't mean New Zealand couldn't do anything. We can, and we did, for example, expand our export controls with respect to Russia and Belarus. So one of the first things we did was issue a Gazette notice which prevented exports going to the Russian military and security organisations, so that companies exporting from New Zealand weren't inadvertently supporting the Russian war effort. We also could do things like travel bans, so we could prevent President Putin, for example, and members of the Russian Federation coming here. But stopping there would have put New Zealand out of step with our international partners and meant that we could have become a safe haven for those sanctions, so sanctioned by other countries to hide their assets. This was not acceptable to the government, but it did present a challenge for officials. An urgent response was necessary. In part because of the urgency, but also because a fully autonomous sanctions regime would have been a significant step for New Zealand, involving a wide range of policy considerations. It was decided to take forward what we call a bespoke approach. So the Russia Sanctions Act is limited to Russia's actions in this conflict and countries that are essentially complicit in those actions. And so far, Belarus is the only other country that New Zealand has sanctioned under the Russia Sanctions Act. The Russia Sanctions Act also allows us to sanction individuals, and they don't necessarily have to be Russian, but people essentially with influence. Adopting the Act also meant that Parliament, not just the executive branch, has taken the decisions that sanctions against Russia are warranted in this context. But the Act itself is a framework. Regulations under the Act are where sanctions are actually enacted, and they also had to be done with urgency. Sanctions aren't straightforward. While they are essentially a foreign policy tool, they touch on a wide range of policy areas that are led by a wide range of government agencies. So we have this interagency task force that brings in financial regulators, transport agencies, customs, immigration, police, so that we can design and implement sanctions. Our regulations currently include asset freezes, goods import and export prohibitions and restrictions, prohibitions on dealing with services, and prohibitions on certain aircraft and vessels entering into New Zealand. So oligarchs is the obvious one that we have heard a lot about in the media, and there's the ship in Fiji that has since been taken to Hawaii by the Americans with a Fabergé egg on it. I mean, just as a personal aside, who carries a Fabergé egg on a yacht? I don't know, but someone clearly does. The test in the Russia Sanctions Act for making a sanction was deliberately flexible to allow for action to be taken quickly. So you will see in the test in Section 8 of the Act, it says complementarity with other countries' sanctions, condemnation against Russia. So it's quite a flexible test, and that was deliberate. But one of the things we've had to learn how to do, which we haven't done before, even though we have UN sanctions on the books, is that we are now responsible for taking decisions about who to sanction, why, what sanctions apply. So we've had to build appropriate processes around those functions. We've also had to consider how sanctions are to be complied with and enforced. So there's a whole range of things to do there, like ensuring that businesses are aware of the sanctions and how they might implement them. Some of our sanctions are quite broad. Partly that's a function of them having to be done quite quickly, and partly a function of the fact that New Zealand has relatively limited exposure to the Russian economy and to Russians generally. But we do have exceptions in our regulations that allow particular activities to continue. So since early March, we've sanctioned about 800 individuals and entities, including most Russian banks and financial entities, and we'll be continuing to announce further sanctions over the coming months. So there's lots of information on our website if you are interested in that. I know it's more of a foreign policy issue perhaps than a legal one, but it certainly required a lot of legal thought into the construction of sanctions and how they are implemented. So the second issue that I was going to talk about today was the International Court of Justice case. Many of you will be familiar with this already, but I'm going to just run through it quite quickly. So as you'll be aware, as part of its justification for its special military operation, Russia claimed that genocide had been occurring in the Luhansk and Donetsk regions of Ukraine. We believe that perhaps inadvertently, but it certainly exposed Russia to legal challenge because it provided a hook for Ukraine to take Russia to the International Court of Justice under the dispute settlements of the Genocide Convention. And the reason for that is because, unlike in many cases, both Russia and Ukraine are parties to the Genocide Convention, and neither took a reservation under Article 9 of the Convention, which is the dispute settlement provision. So it meant that Russia had essentially consented to the jurisdiction of the ICJ. So Article 9 of the Convention says the ICJ has jurisdiction over disputes relating to the interpretation, application, or fulfillment of the Convention. Ukraine filed a case on 27 February, so 3 days after the invasion, arguing that a dispute had arisen as Ukraine and Russia had opposite views on whether genocide had in fact been committed in Ukraine, and therefore whether Article 1 of the Convention provided a basis for Russia to use military force against Ukraine to prevent and punish this alleged genocide. Russia did not take part in the first court hearing in March, but in a document presented to the court, it argued that the ICJ had no jurisdiction because the Genocide Convention governs neither the use of force between states nor the recognition of states. So recognition was an issue because, of course, Russia claims that Luhansk and Donetsk are, essentially independent republics, and that's the way that recognition becomes part of this case. So Russia didn't take part in the court hearing. It said genocide doesn't talk about the use of force between states. It doesn't talk about the recognition between states. And in any case, its special military operation was not based on intervention under the Genocide Convention, but on Article 51 of the UN Charter. So that's exercising the right of self-defense in the event of an armed attack and customary international law. In its provisional measures order of 16 March, the ICJ accepted as plausible Ukraine's argument that it had a right under the Genocide Convention not to be subjected to a false claim of genocide, which is then used as a basis for using force against it. Importantly, because the court accepted that the scope of the case included Russia's military response, the ICJ may be able to make binding rulings on Russia. A clear ruling on the illegality of Russia's actions and the potential to require Russia to pay financial reparations to Ukraine might provide a roadmap and benchmarks for Russia to rejoin the international community in the future. But of course, nothing about that is certain. As a party to the Genocide Convention and a strong defender of the international rules-based system, New Zealand has a real interest in ensuring the Genocide Convention is properly interpreted and applied. For this reason, on 30 June, the Minister of Foreign Affairs and the Attorney General jointly announced that New Zealand would formally intervene as a third party, in this case, pursuant to Article 63 of the International Court of Justice Statute. This is a pretty big deal. New Zealand has intervened in an ICJ case only once before, which some of you will remember was Australia's 2012 case against Japanese whaling in the Southern Ocean. Ukraine has now filed its full case on the merits, and on Friday last week, Latvia announced that it had also filed the first third-party intervention in Ukraine's case. We are expecting a significant number of third-party interventions to be filed in the coming weeks, including our own. So what will our intervention say? A third-party intervention under Article 63 of the ICJ statute means that the intervention must be confined to strict legal interpretation of the Genocide Convention. We're yet to file our declaration, so I can't go into too much detail, but what I can say is that our intervention will be a high-level summary covering the key points with a focus on the scope of both Article 1 and Article 9 of the Genocide Convention, and an overarching obligation to interpret the Genocide Convention as a whole reasonably and in good faith. New Zealand has particular interests in the good faith application and interpretation of legal obligations and respect for multilateral arrangements and institutions, including an effective UN system and effective binding international dispute settlement. And I will leave it there. I'm very aware that Al Gillespie isn't here today, and I know he wanted to have a good discussion, so we talked about enabling that to happen, but unfortunately he's not here today, but very well happy to take questions.
Great, thank you ever so much, Sarah, that's fabulous. What I will do, I don't know if anyone can actually hear me, so what I will do is I will see if anyone has any questions. I know I certainly scribbled down a couple as well, that was really piqued my interest. So if there's anyone in this room, or if anyone wants to put something on chat, in the meantime, perhaps in that, have I said?
Yes, thank you, Sarah, for this very interesting presentation. And I have a couple of questions on one on sanctions and the other one on the ICJ case. And on sanctions is, well, many countries are considering using the frozen assets compensate to be used for the purpose of compensation of Ukrainian losses. And is New Zealand has New Zealand considered to join this type of approach, or what is if you can obviously answer this kind of question?
Yeah, I mean, we can sort of see the attractiveness. Well, I think individuals can see the attractiveness of the idea of ill-gotten gains essentially being used to fund Ukraine's reconstruction. When the Russia Sanctions Act was developed, obviously it was done quickly and under urgency, and the concept of seizure isn't one that's included in the Act. So it would require us to do something else. So while, for example, under the Customs and Excise Act 2018, if you breach customs rules, which could include exporting something in a breach of a sanction, there is a sort of seizure there. There's nothing in particular under the Russia Sanctions Act that would allow that to happen.
So, yeah. Thank you so much. And the second question.
Oh, sorry. No, go for it. And then we'll come to Degeshri and then Dara. Yes. And Trevor.
And the second question is on so there are some countries, Canada, for instance, helping with the investigation before the International Criminal Court. Is New Zealand involved in this, helping this process too? Or?
Well, what we have done is provide, and I'll just get the figure for you, We've put money into the international court investigation, I think $1.3 million. So we are providing monetary support to that, but no other support as far as I'm aware. Yeah.
Thanks, Alan.
Thank you. Degeshri.
Thank you, Juliet. You've provided some very new information to me, Sarah, so thank you. I found it very interesting. You mentioned that it's very rare that we file for third-party interest in such proceedings with the ICC. I'm just wondering, what was the process that was followed for New Zealand coming to the decision that we are going to go ahead and file for a third-party interest in this case?
I think the actions of Russia are so egregious, and we basically want to support the international rules-based system. So supporting the ICJ case by providing our understanding and interpretation of the Genocide Convention is something that's important to us, both for the proper functioning of the international system, but also because we feel very, because of the nature of Russia's. I'm not sure what people heard, but let me know if you missed the end of that and I can repeat it. I'm just not sure.
Do you want to say it again, just in case?
I think the question was, how did New Zealand make the determination to participate as a third party in the ICJ case? And the response was, well, it is a decision for ministers, but factors that were taken into account are, the egregiousness of Russia's actions and using the justification of genocide to justify a war of aggression. And the other important part for us is ensuring the proper functioning of the international rules-based system and supporting peaceful dispute settlement.
So is it just people in the executive, or did you get academics or in other experts who informed the decision making?
I wasn't part of that myself. I think the decision was made relatively quickly. So I'm sorry, I just can't answer that. Yeah.
Thank you. Dara, I believe you had a question.
Yeah, I feel like I'm making you jump all over the place. Really interesting talk. I'm going back to the sanctions. And in the past, when you look at legislation that's been created as a matter of urgency, there are always people who've suffered because of it. So is there any sort of judicial arrangement that's set down in that legislation so that if people feel they've been wronged, sanctioned against, how can they appeal that? Is there a process within the Act?
That's a really great question. So there are a couple of different things. So there is, under Section 13 of the Act, there is a process by which a person can apply, and it doesn't have to be the sanctioned person, can apply and say, I need an exemption because my specific circumstances mean that the sanction is unfair in the way that it operates in relation to me. It doesn't say that, but essentially you can apply for an exemption, and those are the kinds of considerations that might make someone want to apply for the exemption. They can also apply for a revocation of the regulations, so a revocation of the sanctions or an amendment to the sanctions. And that process is essentially goes up to the Minister of Foreign Affairs, although she can delegate some of those functions. So that's one process. So you can essentially, like a delisting process, you could apply for that. Another route you could take is judicial review, is to just to say this decision wasn't taken in accordance with law.
Yeah, thanks. Thanks very much.
Trevor, first, and then on to yourself.
Thank you, Juliet. Thank you for the presentation, Sarah. Really excellent. Two questions. First one, and I'll get both questions together. First one on sanctions. Was there any comparative analysis with the unexplained wealth orders that are used in the United Kingdom in terms of formulating New Zealand's approach to sanctions? Question number one. Question number 2 relates to the crime of aggression, which is something that's regulated, I understand, under the International Criminal Court. And there's been a draft indictment that's been prepared by Philip Sands in the UK and others. Is there any appetite for New Zealand to prosecute the Russian government or the Russian president?
I'll take the first one. I think when the Russia Sanctions Act was developed, it was developed under urgency, but it didn't come from nothing. So some of you, if you've been following the issues around autonomous sanctions for a while, will be aware that there was an autonomous sanctions bill that was before Parliament in 2017. So what essentially the Russia Sanctions Act used that framework, which was, I think, developed in reference to various international partners' frameworks, and tailored that for the situation in Russia with the Russian invasion. So you'll see, if you compare the two bills, you'll see a lot of the same kinds of mechanics, but the test is, of course, different because the test is what relates very specifically to the conflict. So yes and no. And then the other part of, I think, is the development of the sanctions themselves, which again were developed really quickly. And I think that the bill and the initial regulations were passed in just over 3 weeks from the Russian invasion, so very, very quickly. And again, we weren't starting completely from scratch there. We, of course, do have various UN sanctions on our books. And then our partners that we look to, international partners that we look to for these kinds of issues also have their own autonomous sanctions regime. So, well, I'm not sure if we explicitly looked at the UK orders that you mentioned. There were a range of considerations. And appreciating that this all happened very quickly, that's also part of it as well. So there are, we are sanctioning new individuals and new entities, but we're also constantly reviewing the regulations to make sure they are fit for purpose and work. On your second question, I may not be the best person to comment on this. My understanding is that essentially we are supporting the International Criminal Court to investigate concerns around international crimes occurring in Ukraine, and that we have faith in that process. Thank you very much.
Thanks for your presentation. I've been doing a little bit of investigating into this war, and one of the main reasons for this war, according to some top academics in the world like Mesh Sharma and even Noam Chomsky, is the expansion of NATO. And I mean, even people like Noam Chomsky says that there have been agreements for NATO not to expand post breakup of the Soviet Union. So is anyone looking at using international law to see whether this is actually, the NATO expansion is actually illegal? Since it's the cause of the war, the main cause of the war.
The truth is I don't know the answer to that question. I think that the only person who really knows the cause of this war is perhaps President Putin.
Well, he's made it very clear that one of the reasons for NATO expansion, he made that presentation.
Yes. Yes, but I think it's quite a complex situation, and in a way it's not for New Zealand's kind of overarching aim here is for that dispute to be settled in a peaceful way, and whatever I mean, we're not going to get into solutions because it's not our place. President Zelensky, for example, has been very clear with European counterparts when they've suggested, solutions, that it is not for them to make those solutions. So what I would say is New Zealand supports a diplomatic solution to this conflict, and that is our overarching kind of reason for doing what we're doing with sanctions, is to try and encourage that to happen.
Thank you.
Yeah.
Hi. First of all, thanks very much for that. It's not my subject area, and I feel like you've taught me a lot, so I appreciate it. If I could ask you sort of a future-focused question, maybe a little bit speculative. You alluded to the problem of Russia's permanent status in Security Council, its veto essentially. And you've mentioned the Russia Sanctions Act as a workaround to that and a response to this particular situation. But to what extent do you think that as we move forward, that the current rules-based system, the current structure or architecture of the Security Council in particular, actually needs to change?
Oh, that's a really big question. So New Zealand supported UN Security Council for a long time. I guess the issue remains as to, on a system that's based on state consent, what can you actually do? And I don't know if anyone really has the answer to that question, but I think what we did see was a really interesting development in the UN General Assembly. So after Russia exercised its veto in relation to this matter, the UN General Assembly passed that resolution, which now requires, I'll get this right. So it's within 10 days, I think, the permanent member is, within 10 days of casting its veto, the permanent 5 state is invited to justify its use of the veto before the General Assembly. So that's quite an interesting development. And it might, there might be more of a discussion about these issues going forward, given what's happened here.
Do we have another question?
Yes, I just have 2 questions. I'm a law told it's so awesome hearing all this stuff. Like, I feel like this is like heaps of lectures in one, but I just had a question. So because Canada led that kind of press release for the third possible 40 countries possible third party submissions to the ICJ, is there, I have 2 questions. One, is there collaboration between those countries, or is it just basically you wait till the others comes out, then you get to read it?
So that's a great question.
And then my second question is, when Ukraine have to submit these by September, like, is there a time frame under the ICJ procedural rules that the third party submissions have to be submitted by? And what is the time frame?
So just on the first one, I mean, it's obviously for each country to determine, in accordance with their own particular domestic processes, what they will say. And that's the same for New Zealand. But of course, we do talk to other partners who share a similar perspective on these issues. And there have been a range of conversations with close partners about this. On your second question, so my understanding is, and I must admit I don't directly work on that particular issue, is that Ukraine has already filed its full case on the merits. So you will see actually very shortly quite a number of third-party interventions being filed.
There's no time frame that you know.
There will be, but I don't have it on the
That's
top of my
all right.
head. I'm sorry.
I'll find it on Google someday. Thank you.
I have a question, actually, please. Actually, I've got 2 questions. I think I've got 2 questions. I'm just scanning the room to make sure nobody else is waving at me as well, or on the screens. So obviously you talked about sanctions for Russia, and New Zealand sanctions for Russia. Are there likely to be any consequences for New Zealand as a result of those sanctions? And what sort of repercussions might those be?
Sure. I mean, there's absolutely the possibility of consequences, and we've already seen one. So the Russian Federation has put a number of New Zealand politicians and some senior public servants on a list and prevented them from entering Russia, so they have a travel ban on them. So that's a kind of I'm going for retribution, but I don't actually want to say that. I just forgot the word. Reprisal. A consequence, basically, of what we have done. The other things that could happen, and has happened to other countries, is if diplomats are struggling for words today. If diplomats are expelled, thank you. Expelled, then you can get into a tit for tat situation. And I think some of those European missions in Moscow at the moment are fairly light because there's been a sort of a numerical exchange of expulsions of diplomats. Were we more exposed in the trade space, you could potentially see quite a few repercussions there, because we have prohibited some of our exports to Russia, not food, but we have basically prohibited goods that support strategic industries and could therefore be used in the Russian war effort. So you could see reprisals in that area. We haven't yet, and because we had a fairly limited trading relationship with Russia anyway, the consequences, even were they to take retaliatory trade measures, would be relatively small, but could affect some particular businesses quite a lot. So even when you're talking about all of these sanctions, as they might not have overall a huge impact on New Zealand businesses, but some particular businesses could be severely affected.
Thank you. I have one more question, and I think probably Dara's got. In which case, Dara, you.
I was just, it's really interesting. I'm finding this really interesting. It's not my area of law either, but I'm really keen to know. You said that the legislation was passed in emergency, and normally what we would do, especially when we think about judicial review, we would be enabled to go back to Hansard or any of the explanatory notes around when the bill was introduced. Is there any sort of notes hanging around about your task force, how they arrived at the decisions they made, or are those behind closed doors?
Okay, that's a useful question. So the bill was passed under urgency, but there are of course still the Hansard, first reading, second reading, committee of the whole debates that you can go and look at, and they are quite interesting. In terms of the development of the regulations, normally regulations are developed by the executive branch, but you would ordinarily have quite a lot more consultation than as you are able to achieve, obviously, with stakeholders in such a short space of time. So yes, there will be, public records that you could, Official Information Act request, but there isn't the same sort of
transparency.
Yeah, well, I don't want to say. We've done a lot of proactive releases, so you can look on our website, and so some of the papers have all been proactively released. So I encourage you to go there. For the bits that haven't been proactively released, because we are sort of getting those done as we go, then you can always request that information.
Well, thank you very much. Thank you.
Thank you. We do have a question from somebody in Zoomland, and Nalini. Nalini, if you'll just take yourself off mute and ask your question. Thank you.
Kia ora, Sarah. Thanks for your kōrero. Nalini Singh here from PACMM. I'm not sure exactly how to word this question, and there may be only so much you can say on an unclassed line, but you made the point that there weren't strong trade interdependencies with Russia, so the consequences of those sanctions back on New Zealand hasn't been too high. I just wonder also, I guess, a forward-looking question, if another large player were to, somewhere kind of west of here, who we do have large trade interdependencies with, if they were to invade another another location, would we be so forthcoming with sanctions and the way we've responded to Russia? And what has any thinking happened around that?
I think I'm going to stick to what the Prime Minister has said on this matter, which is let's deal with the situation in front of us. What we have here is a situation where a country has illegally invaded another country, and the Russia Sanctions Act is a direct response to that. As I said in the beginning, whether we should have an autonomous sanctions regime like other countries have is still an open question, which I'm just really not in a position to comment on, as it's still under consideration by the government.
And I think perhaps on that note, we should let Sarah take a big deep breath and to say thank you so much. Everyone for your wonderful questions. And before we just go to a break, because that's what we're about to do, I would just like to acknowledge two people that are guests on Zoom, in case no one has spotted them so far. And that is Sir Kenneth Keith is here on Zoom, and you are very welcome. We're delighted to have you here as well. And also Jane Kelsey as well. So thank you both for coming on today and listening to us. And so I think tea and coffee would be a good idea for everybody, yes, and stretch of legs. So we'll say 15 minutes, yeah, and then come back for our next fabulous guests. So I will now put this on mute. Thank you very much, everyone. Right, welcome back, everybody. Have a nice break. What I'd like to do now is I would like to introduce our next speaker. We're going to have two speakers in the next session. Unfortunately, Sarah was on her own. Well, not unfortunately, because she was absolutely fabulous, but there should have been Professor Alvarez-Jimenez as well joining her, but unfortunately, Al's been taken sick, so I couldn't make it today, which is a real shame, but I think Sarah did fabulously. So our next speakers, the first of them joining us in a short while is Professor Barry Barton. As so many of you will know, my esteemed colleague, Professor Barton, for those of you who do not, Professor Barton is a specialist in energy and natural resources law. He is the director of the Faculty Centre for the Environmental Resources and Energy Law, and has been working on climate change law issues for some time. He introduced climate change law as a fourth-year paper in the faculty curriculum in 2020, and he's been teaching it ever since. And that is a very brief bio, Professor Barton. So without further ado, I'd like to welcome Professor Barton to the stand.
Thank you, Juliet. Thank you, everyone. Brief bios are good bios, I think. So, but thank you for the welcome. Can people hear me okay, especially people online? Yeah, okay. Thank you, Amy. That's great. Yeah. What I propose to do is just make a few remarks about sort of the national setting, and before moving on to the international setting. Again, very briefly, there are people in the room and online with a great deal more expertise on these matters than I have, being a mere domestic municipal national lawyer. First of all, what is our New Zealand context, the political context in which we're working and making laws? It's one of quite striking political consensus among the political parties. And that's been the result of a lot of hard work by people like Kennedy Graham, David Parker, and of course James Shaw, previous co-leader of the Green Party. As an academic, I can make witty remarks about the politicians, and I know that colleagues in civil service have to exercise restraint, so we respect that. So a lot of hard work has gone into this consensus, and which is quite remarkable. And it is, for example, on our position going into the Paris Agreement, our position on the Zero Carbon Act elements, the target, the budgets, and the plans process that goes through it, and the emissions trading scheme, the New Zealand emissions trading scheme. But at the same time, I would see it as a shallow consensus, a vulnerable, fragile consensus. And you see that in local bodies. Everyone's prepared to sign on to say that there is a climate emergency, but if it comes to taking away one of the road traffic lanes, making it into a cycle lane, all hell breaks loose. So we're prepared to talk the big talk at one level. When it actually comes to changing behaviour, it suddenly becomes harder. That is a complication. We see it in agriculture too. Those of you who are not climate change nutters, it is about getting on for half of our emissions in the form of methane. There's an issue there about how you calculate the relationship between methane and carbon dioxide, but leaving aside, huge amounts of money has gone into research. We don't need any more of that. At some point, that sort of funding of research becomes an excuse for not actually taking action and asking for reductions. But it's a big feature of our emissions profile. It is one we're making progress. It's going to be hard work in the next few years. And it has possible implications in things like trade. For example, if we are seeking new trade agreements, although perhaps we're at a stage where there won't be that many in the next while, we could expect questions about what are we doing about agriculture emissions. We have measures coming out slowly for addressing climate change other than the emissions trading scheme. And, for example, we've got the clean car standard and the clean car discount. So those are emerging, but again, it's real slow. Everyone's in favour of the Paris Agreement. In fact, even OPEC is in favour of the Paris Agreement, they said so. But to change the way we do things, that's proving to be a real challenge. Latest example, energy efficiency standards for new building in the building code. It's been postponed only for 6 months or so, but they say it'll be 200,000 tonnes of extra emissions of CO2 equivalent as a result. It's a lot. So, climate change, yes, but it's something very postponable because we've got a crisis in the building industry and so forth. That sort of thing is a persistent problem. In energy generally, we still import a lot of fuel. We import the greater amount of our fuel in the form of oil. It's priced in US dollars. So when the New Zealand dollar is not doing so well, it's costing us more. So that continues to be a point of vulnerability. There's a whole bunch of issues about adaptation to climate change that a whole field of nettles that we haven't grasped yet. How seriously do we stop people from building in places where they'll be vulnerable to floods, river floods, to fire? We never used to get forest fires in New Zealand; it just wasn't a thing. Now it is, and coastal. So the domestic agenda is fairly full. There is a sense of urgency that isn't there now, but is it enough? Is it really enough? Not really. Yeah. Right, on the international front, the landmarks are the Paris Agreement of 2015 and the Glasgow Climate Pact late last year. And those were big, important events. And it's great that we've got people who were actively involved who are going to tell us about. Personally, what I'm quite interested in is Article 6, international trading in units. So this is where it gets a bit technical. But if New Zealand can buy cheap units from some other country, cheaper than we can produce them ourselves, then why shouldn't we? The climate doesn't care where the reductions are made, is the argument. The new regime is going to be much tougher than we have seen before. And New Zealand is going to attract particular scrutiny because under Kyoto Protocol, we were guilty of considerable misbehaviour in importing huge numbers of units from Ukraine, Belarus and Russia that were pretty obviously not consistent with good audit practices. Okay, that's a polite way. So they're probably rubbish. So that's a big deal. Those units won't be cheap, but one of the drivers from the national front is that we've got we need them. We are not going to meet our Paris Agreement nationally determined contribution without them. So they're going to be expensive, I think, because they're going to be of pretty high quality. Under Paris also, we've got the enhanced transparency framework, which is the way of talking about compliance, enforcement. It's all very delicate and political solutions rather than setting up a new court that can punish countries or anything like that. But that will gradually assume a great deal more significance, I think. For my part, as someone teaching in the area, as Juliet says, it's going to be interesting to see how that develops. Another aspect is the Pacific side of things. And the Pacific Islands Forum, the case that Vanuatu is proposing to take to the ICJ. Australia's changed, but we need to change too. We think, we've come to talk about China. A lot of people in the Pacific says, well, actually, we want to talk about climate change and we want to talk about it from an equity point of view. You're not doing enough to redress the problems that you have imposed on us. Trade is a very interesting area. We have seen a new set of trade agreements, and New Zealand has signed a trade agreement with the United Kingdom. We've got the text of it. It has a sub-article there about climate change quite specifically, and where the parties agree to implement the Paris Agreement. It'll be interesting to see where that goes. Does that mean, what does it mean to actively implement? Does it mean that NDCs have to be progressively better? Does it mean that our nationally determined contributions, what we promise to say we will do to reduce emissions? Does it mean that we can't slip behind international expectations in terms of the ambition of our nationally determined contributions? Those agreements could be challenging. So the one we've entered into recently with the European Union, I haven't seen the text of that yet, but I suspect it will be more demanding and more complex than the one with the United Kingdom. Related to that is a rather obscure area, but one I think will be quite important in the coming years, called border carbon adjustments, or the Europeans call them CBAMs, carbon border adjustment mechanisms, I think. And the way to think about that is that every time you produce a ton of, say, cement or steel or something, you have to produce vast amounts of carbon dioxide. There's sort of no way around it. Now, if the cement manufacturer is the New Zealand one, then they are subject to the emissions trading scheme, and there is a price on carbon. Okay, if we import from Thailand or China, there probably isn't. So those imports can undercut our domestic production and put our domestic producers out of business. And it's not just a New Zealand problem; it's an issue everywhere. Sometimes called carbon leakage. So you have very effective policies in New Zealand, but actually the emissions continue just somewhere else. Yeah. So how to deal with that? What we've been doing up till now is basically giving out free units, industrial allocations under the New Zealand emissions trading scheme for emissions-intensive trade-exposed industries, like the cement manufacturers, steel manufacturers, aluminium smelter, etc. But that really undercuts the emissions trading scheme. And we can't go on like that. So it's going to be interesting to see, as I understand, Treasury is taking the lead in figuring out how we can do one just for cement, which is a sensible place to start. Anyway, those are some of the issues that I see floating around. And I look forward to hearing, hopefully, what Arun has to say to take it into real depth. Thank you.
Thank you very much indeed. That was fabulous. Thank you so much for that. I've already got questions scribbled down. What I would like to do now is introduce our next guest speaker, and I have a horrible feeling I might have pronounced your name incorrectly. Arun Jain?
Arun.
So, Arun is a legal advisor in the Ministry of Foreign Affairs, Environment and Resources Law team, and has been there for the last 2 years. And he covers a range of international environmental issues, particularly the Antarctic Treaty System and climate change. And prior to this, he was on 1 year's study leave, completing a master's in the UK, which I believe was Oxford. And fabulous city. And he worked in the Ministry's Trade Policy Negotiations divisions on their free trade agreements with the UK and China. And he started his career as a litigation lawyer in a large firm in Auckland. So please, we welcome you up here.
Thank you. No mai haere mai ki tēnei kōrero. No te whanganui atara, tōku kāinga tupu, no tamaki makaurau, tōku kāinga noho. E mahi ana hau ki te manitu aorere, ko kaito tō turea hau, ko Arun Jain, tōku ingoa. No reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Hello everyone, my name is Arun Jain. As I said, I'm a legal advisor at the Ministry of Foreign Affairs and Trade, and I work in the Environment and Resources Law Unit on the Antarctic Treaty System and climate change issues in particular. It's my pleasure today to be speaking to you about international climate change law, for which I have about 10 minutes. So it's a very large topic to cover in that amount of time. I'll do my best. So I thought I'd present a few themes for us today on what's happening in the international climate space, and then we can have a discussion afterwards. I'd also like to thank the University of Waikato for hosting this discussion, and for Barry for the initial remarks, which in some cases went into more detail than I was planning to. Never mind, we can go into a discussion later on. So first of all, since this is an international law colloquium, I thought I'd ask a general question. What is international climate law? So in some ways, it's quite a orthodox conception of public international law. It's about states coming together and cooperating to achieve outcomes of mutual interest. But in another way, it's a bit unusual, as it asks states to join together out of common concern and to take collective responsibility for a shared problem in spite of nationalist or sovereign interests, or at least in theory it does. In terms of its content, I thought it might be useful to talk about international climate law by reference to the main treaties that it comprises. Those are, as Barry said, the UNFCCC, the UN Framework Convention on Climate Change, and the Paris Agreement, which are two treaties that I work on quite a bit. So I'll go through each of those in a little bit of detail and point out some key themes. Starting with the UNFCCC, the UN Framework Convention on Climate Change. The negotiations for this convention started in 1990, and the convention was adopted after about 15 months negotiation in 1992. So it shows that we have known about the problem of climate change and have been trying to do something about it in the international space for a very long time, much earlier than I previously realized. So in this convention, nearly every country in the world agreed that human activities have substantially increased the greenhouse gas content of the atmosphere, and that this will result in the warming of the earth and harm for ecosystems and humans. Just to pick out a few key features of the convention, the stated objective of the convention is to achieve the stabilization of greenhouse gas concentrations in the atmosphere to prevent human-driven interference with the climate system. The convention's objective also refers to action being taken within a time frame that ensures, one, that food production is not threatened, and two, that enables economic development to proceed sustainably. So at the outset, we can see that the objective of the convention is tempered somewhat by social and economic considerations. Another feature is that the convention expects developed countries to take the lead, both as the countries that have historically and presently contributed the most to the climate crisis, and as the countries that generally have the most resources to do something about the problem. In the UNFCCC, these are referred to as Annex 1 countries because they're literally annexed to the convention, and that list includes New Zealand. And the final sort of feature I wanted to point out was that the UNFCCC also introduced the language of common but differentiated responsibilities into international climate change law. So this reflects that while climate change affects all countries, some have contributed more to the problem than others, and some are more vulnerable to its effects than others. So this is an initial basis in the agreement for climate justice, which continues to be a theme throughout the negotiations that I've been a part of. But ultimately, the UNFCCC is just that, it's a framework. It doesn't set substantive goals on parties. Instead, it establishes a basis on which the world could come together to cooperate to address this issue of climate change. And the way that we did that, leaving the Kyoto Protocol aside, is the Paris Agreement, which is the next international piece of climate change law that I wanted to talk about briefly. So the Paris Agreement was signed in 2015, as Barry said. It continued to build on the UNFCCC's assumption that countries will have common but differentiated responsibilities for this issue, but added to that, that action will be taken in light of different national circumstances. It also importantly added performance measures to the UNFCCC's objective, including the aim to hold the increase in global temperature to 2 degrees of Celsius above pre-industrial levels, and to pursue efforts to hold the temperature increase to 1.5 degrees above pre-industrial levels. Another interesting feature of the Paris Agreement to point out is that it actually contains very few legally binding obligations. It's a legally binding treaty like any other, but within it, there are very few obligations that bind states to a particular course of action. We call those shall obligations because that's the word used in the convention to describe those kinds of obligations. So there's no obligation for any country to pull its weight in achieving the temperature limitation goals of Paris. And nothing happens legally if they don't. The only thing that can happen is political consequences like criticism or naming and shaming, if you like. One of the few binding obligations that there are in Paris is the obligation to maintain an NDC, or nationally determined contribution. So an NDC is a statement of a country's ambition and the actions that it plans to take to reduce its emissions or to adapt to climate change. NDCs must, under Paris, be updated every 5 years. Paris expects them to represent a succession or greater ambition than the previously prepared one. And again, Paris expects that developed countries will take the lead in undertaking economy-wide emissions reduction activities. So in New Zealand's case, our first NDC was presented in 2016 and updated again in 2021. The update from 2021 includes the targets to reduce greenhouse gas emissions to 50% below 2005 levels by 2030 and to zero by 2050, among other things. So while the Paris Agreement is a concluded legal instrument, there are a few outstanding issues that continue to be discussed. So every time you see in the news that there's a big climate meeting, these sorts of issues tend to take up the majority of that discussion. So one of these remaining issues is climate finance. In other words, how much money developed countries should be giving to developing countries to support their sustainable development and also mitigation and adaptation activities, given the initial opening that developed countries are expected to take the lead. Developed countries are required actually under the Paris Agreement to provide climate finance, but there's still plenty of disagreement about how money should be paid, to whom, and in what contexts. In a similar vein, another challenge that comes up time and time again is what we call loss and damage, which is just a way of saying compensating vulnerable countries for the effects of extreme weather events that are brought on by climate change. Again, there are similar questions for loss and damage payments about how much is owed, whether compensation is needed, and also about whether particular extreme weather events can be attributed to climate change at all. Either way, extreme weather events, as we know, will continue to become more common and more severe as the climate crisis worsens. And we've seen plenty of examples of this in the news recently, close to home and further afield. There are also continued discussions, as I said before, about climate justice and historical responsibility for climate change, particularly the unique roles within the overarching legal framework of developed and developing countries. They continue to crop up in almost every circumstance that I've seen in these meetings, and I doubt whether we'll ever see the end of it. And the final continuing and ongoing discussion that I just wanted to flag was sort of the monitoring and measurement of how we are doing as an international community in our efforts to tackle climate change. There's a new topic raised at the recent bond meetings for the first time called the global stocktake. Not a new topic, sorry, but a new discussion that opened about how we measure our success in this forum. And it's a very technical process that I can't profess to have understood almost at all, but it's very complicated. So these are some issues that we don't have resolution on, but we have been able to make some good progress on others. We've agreed guidance standardizing the form and contents of nationally determined contributions and guidance on how parties to the Paris Agreement can buy and sell carbon credits to one another to increase their climate ambitions, which is known as the Glasgow Rulebook. But there's a lot more work to do, and by no means done with the conclusion of the Paris Agreement itself. So the Egyptian government is hosting the next conference of the parties to these two treaties, which is known as COP27. It's the 27th meeting, and that's being hosted in Sharm el-Sheikh later this year. I think it's in November. And we certainly hope that we can continue to build progress on these issues at that meeting. But as you can imagine, just like in many other aspects of international law, when every country in the world is sitting down and exchanging views to agree an outcome, it can be very slow going. So before I conclude, I just wanted to mention a couple of other contemporary climate change issues that have come up in the MFAT space that you also might have seen mentioned recently. The first is an issue that I've been working on lately, which is the international efforts to seek an advisory opinion from the International Court of Justice on climate change. Vanuatu is leading the charge on this piece of work. It's leading the charge to build international support for the court to consider the obligations of states to protect the rights of present and future generations from the adverse effects of climate change. So an advisory opinion from the court does require a majority vote in favour at the UN General Assembly. The next General Assembly meeting is starting in September this year, so we expect the issue to make some progress there. At the recent Pacific Islands Forum, which was held in Suva, New Zealand, along with all the other forum countries, called on the UN to request the opinion, which is particularly relevant as small island developing states, which comprise the majority of the Pacific, will be particularly vulnerable to the effects of climate change, and particularly to sea level rise related to climate change. But at the same time, it's also important to make sure that if a question is posed to the International Court of Justice, that it's done so in a way that clarifies states' legal obligations, that doesn't muddy the waters of the delicate balance struck in the Paris Agreement, and that supports ultimately greater climate ambition. And the second sort of contemporary issue that I wanted to mention is one that Barry's also mentioned, the trade agreements and climate change in that space. So yes, we have recently concluded 2 agreements with the UK and with the EU, 2 of the world's largest economies, which include some pretty groundbreaking provisions on climate change as far as a trade agreement is concerned, at least. So in the UK agreement, New Zealand and the UK reaffirmed their commitments to the Paris Agreement. Obviously, we're both parties to it, and the temperature limitation goal, and have agreed to promote between us trade that supports its objectives. We've agreed to take steps to eliminate harmful fossil fuel subsidies, which is a first in any trade deal that New Zealand has struck. And in our trade agreement with the EU, each side's Paris Agreement commitments are now subject to binding dispute resolution in the context of a trade agreement, which is the first time that we've agreed something like that. So the unprecedented forward-leaning nature of these agreements in the trade context indicates that international climate law has continued to grow beyond its narrow mandate, or sort of its more narrow mandate, shall we say, so much so that countries are now using the issue to define and enhance the relationships between them, even in spaces that were traditionally seen as unrelated, such as trade. So that's all I had to say, and I'm sure I'm running out of time. And I wanted to open up for a discussion, but I want to thank you all for your attention and welcome any questions from the room or Zoom.
Thank you very much. That was fabulous. So what I thought we would do is as we did previously, Barry, if you want to come back up again in that case, so we can have a look at you on the screen as well. So I will keep an eye on Zoom, and also any questions from the room. Also, you can ask of either or both. I know I've scribbled some questions down. So I will step over here and see if anyone wants to ask any questions anywhere. Nathan first of all, and then Alberto, Kanama, and Gay, and then Trevor, and then Sam. Right. Few then.
Thank you both so much. That was fabulous, and obviously right up my street. So, however many questions we're allowed, really, Juliet.
Should we just do one for the time being?
I am joking. So, okay, with only one then. You mentioned, particularly Aaron, you mentioned the absence of binding legal obligations in Paris, and actually, what's left then is so much reliant on political pressure, on will, on pressure otherwise. And so I'm wondering, with the next COP due in Sharm el-Sheikh at the end of the year, how different an environment are we going to see around COP27, and what might be the consequences of that compared to some relatively successful protest and pressure brought to bear at COP26?
Well, it's always $1 million question, I suppose, with COPs, is how much pressure can we make at each one? I think with the Glasgow Climate Pact, for example, it was looking until the 11th hour like we weren't going to get anywhere on, the Glasgow Climate Pact is the agreement reached that countries would phase down their coal consumption. And it looked like we weren't going to get there because China and India held off until the very last minute on the phase out language. They preferred phase down. But I suppose if you'd asked me the same question a year ago, I wouldn't have been able to tell you whether that would have gotten through either. So to be honest, it comes down to the will of the people in the room, the mandates they have, and it's often very hard to know in advance what to expect. The kind of issues that I mentioned before, loss and damage, climate finance, are the ones that we will talk about. The global stock take is due to take place by the end of next year. So there'll be a lot of discussion on that. There wasn't much progress, to be honest, at Bonn in June this year on that. Sorry, I feel like I've just gone around in circles instead of answering a question, but it kind of is like that in the UNFCCC, to be perfectly honest.
Thank you very much. I think it was Alberto next.
Thank you so much, Juliet. Well, thanks both for your great presentations. And I have a question for Arun. And so regarding the ICJ advisory opinion, and what is the range of questions that the General Assembly is considering, or the members are suggesting? What kind of different options regarding the questions is the General Assembly exploring, or will eventually explore?
Yeah, that's a good question, and that's actually the question we have as well. We don't actually know. The campaign is being led by Vanuatu, and in principle, we're on board with it. It's just how the question is ultimately framed to the ICJ is essential, because if it disrupts the delicate balance in the Paris Agreement, then it could be counterproductive. The only formulations we've seen of the question so far are along the lines I read off before. That was obligations of states to protect the rights of present and future generations from the adverse effects of climate change. But that's not the final question. That's just an example that we've seen. And actually, New Zealand's not a part of the discussions for shaping up the final question. That's being done with a smaller group of Pacific Island states. But we'll be watching that closely and making sure that it's taking us forward.
Thanks a lot.
Thank you very much.
Oh, thanks so much for the speech. So my question is about climate finance and $100 billion a year from developed country to developing country. So my question is about New Zealand. So how do you think that, like, in what stage we are in supporting, for example, especially the Pacific region? Because if you look to the global level, we never, in the last 6 years, we never reached to the 100 billion euro. And also there's a question about, for example, the fund that this fund use it for renewable energy or not. But in terms of New Zealand, how do you assess the New Zealand in terms of financing, especially Pacific nation? I know you or Barry would have.
Yeah, I think you're right, and the focus on the Pacific is definitely the same one that New Zealand as a country has. So we do a few things in that space. We have I think it's 1.3 billion we've dedicated to supporting Pacific climate resilience and climate development. We also support many Pacific Island countries to physically attend the COP meetings so that their voices are heard, particularly the Cook Islands and Niue, and we have particular legal obligations to topical. So I think you're right that more needs to be done, but as far as what we're doing to support the Pacific, that's certainly our focus, and I think we're definitely devoting plenty of resources to it. I don't know if it's, well, not even plenty, a lot of resources to it. I don't know if it's enough.
Perhaps the one thing I'd add is that a lot of discussion within a country, like within New Zealand, about something like finance or loss and damage, misses the fact that to most of the international community, the whole thing is a question of equity and fairness and justice. You mentioned climate justice and how heavily that weighs on the minds of most of the people at these meetings. You know, there's that great book by Kim Stanley Robinson, Ministry for the Future. Come across that? And it's got this classic line where the people facing, you know, deaths of 20 million people in India, this is fiction, but it's near future fiction, turn around and look at the Westerner and spits out, you did this. You did this. You know, and that's how a lot of people in many countries see climate. They see it as an equity issue. Decolonization, fairness between states, accountability, responsibility. And that's kind of missing within the national debate, isn't it? It doesn't come up that much. But if people are wondering, why do we have to make all these efforts when we're already the most efficient producers of beef or mutton or milk powder? That's part of the answer, isn't it?
Thank you. I believe it's Gay next, actually.
Yeah, my question, thank you. My question kind of follows on to the equity point. I was just wondering, with loss and damages and the duty to compensate, well, A, you know, is that firm? And B, how has loss and damage been defined? How broad is it? How narrow is it? Is it just catastrophes, or is it increased costs, or has anybody fleshed out what that term actually means, loss and damages, what it encompasses? Because I mean, it could be quite complex. Yeah.
I think the answer is no. I'm not 100% sure about that, just given my relatively limited engagement with loss and damage. But I think that's one of the main issues: is what does it cover? When is it owed? I don't think we've landed on a definition for it yet either.
Yeah. But yeah, how are people gonna? Yeah,
It's in the Paris Agreement, loss and damage, but it's not defined there. And different countries have different views depending on how it affects the specific circumstances.
Yeah. Okay, that was my question. Just if anybody had anything besides those two words.
There's been a lot of discussion on it. To be honest, I don't know where the current level point is, but it's not going away anytime soon.
Yeah, thank you.
Thank you, Gay. So we've got Trevor, then Sam, and then Rachel online. So over to Trevor.
Thank you. Two very brilliant presentations. Thank you very much. I have one observation and one question. The observation is in relation to how do we monitor how we're doing. There's the Oxford Climate Tracker, which is updated quite regularly. It's New Zealand and a number of other jurisdictions in the unsatisfactory category, where on current policies, if they're to be pursued, would lead to a 4-degree warming world and not a 1.5-degree world. The question relates to the trade agreements, and there, are we just seeing something that's sort of mirroring what's happening in national jurisdictions and debates where the action is increasingly outside of standard climate action instruments. No one's litigating climate change law in terms of statute law here. They're taking judicial review cases. They're seeking amendments to the Bill of Rights for a clean and healthy environment. Is the angle that's being pursued now through trade agreements just really a mirror of that on the international climate?
On your statement, I completely agree. There's many trackers and all of them are not particularly satisfactory, even of particularly complementary, even of New Zealand's updated NDC, and we're not alone in that. I think most developed countries are still showing unsatisfactory. One shows it as highly insufficient, I think. Yeah, it's completely agree with your statement. And on your question about trade agreements, I'm afraid I'm not a trade lawyer, so I couldn't probably give a good answer, but my feeling is that where countries are entering into a bilateral free trade agreement and they're putting climate change considerations into it, it's because they regard it as an important way of structuring their agreement, even in a trade space. But as far as whether it's along the lines of climate litigation, I'm just not sure. Sorry.
I suppose what I could add is that the consequences are different. You know, if one party tackles the other in the processes there, and the conclusion of the adjudication is that, you know, New Zealand can't do what it's done and it has to do better, then that will actually be binding on New Zealand, and parliamentary sovereignty won't get us out of that without essentially disowning the agreement. So there is that difference.
Thanks, Barry.
Thank you. So we've got Sam, and then we've got Rachel, Opie, and Nalini Singh as well. Thank you, Nalini. I'll come on to you after Rachel. Sam.
Brilliant, thanks. I'm really interested in your experience working in the Antarctic space as well as the climate change space. And my question's about a comparison between those two experiences. New Zealand's obviously been a real champion of the Antarctic Treaty and seems to see its role as a real champion of promoting that treaty. Do you think the country, pardon me, do you think the country sees its role as similar in the climate change space as being a champion, or is it more pared back?
It's a really good question. I suppose the role we have in the Antarctic Treaty System is more concentrated because there are fewer members. I mean, the Antarctic Treaty System, Antarctic Treaty Consultative Meeting has 54 members compared to 197, I think it is, for the UNFCCC. And New Zealand has a historical claim to a part of Antarctica. We have a long history of Antarctic science, and we're a gateway country to the Southern Ocean and Antarctica. So in some ways, our position in that forum is magnified compared to the UNFCCC, which is purposefully meant to be about every single country having common but differentiated responsibilities. But there's a lot of parallels too, because what happens in international climate happens in Antarctica more than anywhere else. There's 65 meters of latent sea level rise if Antarctica were to melt, which is completely disastrous and unthinkable. So we have to be champions in both. It's not about choosing at all.
Thanks.
Thank you. And now we come on to Rachel Opie. So Rachel, over to you.
Kia ora, and thank you very much. Thank you both for the introductions to the work that you're currently deeply involved in. It's extremely interesting. My question might not be, and I fully appreciate this, within your areas, and so please shout out if that's the case. But I'm really interested to know if you can comment at all on what might be New Zealand's position on the evolving international crime of ecocide, particularly as it might correspond to any future action or responses to the lack of action on climate change. Thank you.
Really sorry, I don't know. I don't think I can comment on that. I just don't know, to be honest.
All right, no, that's interesting. Thank you. No, thanks. I just wanted to check whether it might be something that's come across your desk. Thanks very much.
Barry, do you have any thoughts on that?
Well, there's a lot of interesting, challenging on the front foot efforts in legal scholarship and an advocacy to work out new ways to do things, and that is one of them. Which ones will come home as being effective in bringing about real change? I don't know. A lot of the things we take for granted now, of course, are things that, before they came in were thought to be crazy stuff. So we have to keep our ears open, don't we?
Yeah, we certainly do. I think I'm happy to see. I think it might be progressing beyond the zone of crazy stuff, but you're right that it's still in its development. But thank you very much.
Thank you, Rachel. Nalini, please, over to you.
Kia ora. This is more of a question for Professor Barry Barton. You mentioned the urgency of climate change, and despite a lot of rhetoric, there hadn't been much action. One thing I've been thinking about a lot is the wero that Minister Mahuta has sort of thrown to us, which is what does indigeneity mean in development assistance, and I suppose in particular in climate development assistance. And one of the criticisms that are often levelled at development work across the board is the lack of meaningful participation and partnership and really building relationships with people on the ground, which takes time. And in Te Ao Māori, and as well as many Pacific cultures, it's 1,000 cups of tea. So how do we balance those two things in terms of going fast, but also, ensuring that we really are upholding both our treaty obligations, but as well really honouring Pacific whānau and their mana and agency, and those relationships and that process in this existential crisis.
Yeah, thank you. I'm not deflecting it, but Rob Joseph is going to talk to us shortly about the way that New Zealand's international positioning has changed substantially in relation to the Maori dimension of New Zealand. There is a lot that New Zealand generally needs to learn from Maori about understanding the relationship between humans and the environment, and climate change is one of them, absolutely. As I understand it, many Maori people see the climate justice issues affecting or being ones that entail their interests in a substantial way, and that's very obvious in some circumstances. I quite agree that about 1,000 cups of tea, and a lot of these things aren't going to change without work and effort and struggle everywhere. What we need to remember is that the international law dimensions of it are only one part of it. They're dealing with relations between states. And nobody who's involved in that would suggest that that's the end of it, and that you bring it through into international law and institutions, but that isn't the end either. And bringing it through into how people think and talk to each other and talk to children, and how do they find ways that they can change. A lot of those things are absolutely incremental, and there is no sort of giant policy measure that can be taken. As soon as we do that, we're done. It's not like that. And climate change, perhaps, one of the differences from Antarctica is that it in the way, especially in the way we use energy and the way that we consume food, it affects every dimension of how we live. It's not a point form problem. It pervades everything in terms of our civilization, our economies, our way of life. That makes it tough.
Thank you, Barry. I just had Bruce Burson has just commented, and Bruce, I'm going to call you in that case. I'm just going to leap in before the others that have put their hands up as well. He says that he's a consultant at MFAT on climate mobility, and he said there are things that we're doing which relate to Nalini's question. So perhaps, Bruce, if I could ask you to speak on this as well. Thank you.
Sure, thanks. I won't be long. Kia ora, thank you for giving me the opportunity. Look, yeah, Nalini, absolutely right. And it's part of the Climate Mobility Action Plan that was announced in 2018 by Minister Peters. MFAT have been embarking on a number of activities in relation to that, and I'm advising on an external basis in relation to that. And we've just had a procurement process, and we're contracting for that to really try and ground understandings on what a climate affected future looks like for Pacific communities in terms of human agency. Do they stay? Do they go? If they do decide to go, where might that be? And part of the function of that is to build from the ground up and using Pacific methodologies and Pacific researchers, a truly organic Indigenous understanding of the issue to try and drive more sensitive and nuanced development policy going forward, and perhaps in long term might even feed into immigration settings. You can find it all, I think the terms of reference for the project are all publicly available on MFAT's website. So just something to say that's something that is front and centre of the project that I'm involved in with MFAT, and trying to do exactly as you say should be done. And it's quite exciting. We hopefully to be finished contracting and begin to have the research underway later in the year. So just thought I'd jump in there and say that. Thanks very much.
Thank you very much indeed, Bruce. So we have Lars, who's going to be asking a question next. Thank you.
Yeah, one of the ideas that I think would be really good for reducing excessive consumption and reducing our impact on climate is to tax aviation gas. Apparently, for international reasons, aviation gas is not taxed at all. And that would, if they did able to tax it, there would be an income stream to fund a lot of initiatives in developing countries. So has there been any discussion on this idea at all?
I might be wrong, but I don't think aviation has come up much in the UNFCCC Paris space. I think it's done more in ICAO, the International Civil Aviation Organization. I could be wrong about that, but I certainly haven't come across that specific point raised, and I completely agree. I think it's a very valid point.
It's the International Civil Aviation Organization that has been working on that, and there's a parallel process in relation to international shipping. So there is no tax and there's no obligation to surrender New Zealand units for aircraft leaving New Zealand or arriving. There is nationally, Air New Zealand has to surrender units for domestic travel. Yeah. But for the international, yes, it's out there. It's one of the wedges, it's sort of 3 or 4% of total global emissions, not insignificant. And there are apprehensions that it being particulate matter being emitted into the higher levels of the atmosphere has a particular influence.
Thank you very much. So we've got a number of people waiting to ask questions. So I believe I've got this correct. If we can go to Nathan, then Emmeline, and then Alberto, and then Gay, and then I'm very cognizant of time, and I've already had to call the questions to a halt at that particular point. So Nathan, please, thank you.
Thanks, thank you both. A question for both of you, really. You've both mentioned the nationally determined contributions, the NDCs. What we saw at COP was a raising of the bar by many countries in that respect, including New Zealand. But we've also seen, as Trevor reminds us, that many of those new pledges are still falling far short of the necessary target. There was also a lot of discussion at the last COP, particularly from African nations, around trying to move towards annual redetermination of national of NDCs to try to sort of ratchet things up. Are we going to see a more ambitious NDC from New Zealand anytime soon, or are we going to have to wait for the next 5 years?
I'm afraid I work in foreign affairs, and what the government does nationally is kind of not something I'm really across. So You're right. I mean, I think on current projections, all of the targets, even if they were met to 2030, would still see a 2.4 degree temperature increase. So it's clear that much more does need to be done across the board.
It's crystal ball gazing, Barry.
I suppose the existing rules under the Paris Agreement are that we are obliged to do it every 5 years. I think we can do it more rapidly. I can imagine governments not wanting to go through that, from a domestic point of view, any more times than they have to. Would it make a difference? It could. There would be significant effort required in what Arun has mentioned in the incredibly complex businesses of assessments, measuring, and reporting. Those people will probably run from rooms screaming about just how fiendishly complex that would be. So yeah, it could be out there, couldn't it?
Thank you. Emmeline.
So mine's a very short, specific question. So in relation to the Climate Change Response Act and its reference to tikanga, te tiriti and consultation with iwi, is there someone, other than, obviously we have the Minister of Climate Change, but is there a specific role or position or someone in MFAT that they're like the go-to person in relation to meeting, I guess, those commitments by the government under that legislation? Like I was just trying to, like, do you have someone, is there someone in MFAT? Who is that?
MFAT doesn't administer the Climate Change Response Act. That's administered through the Ministry for the Environment. That's the domestic facing agency. So MFAT's kind of responsible for the international negotiation side of things, but the domestic framework is administered by domestic agencies, Ministry for the Environment, Ministry for Primary Industries.
Okay, so it's under the different environments, just so it's got nothing to do here.
But there is a climate change division within MFAT that exclusively focuses on our international engagement on climate change issues.
And within that division, there's not a specific role. It's just like more people like that. I think Bruce was talking from, he works for MFAT.
Yeah, climate mobility.
It's just general people that work in, it's not a specific role.
But if your question's about the Climate Change Response Act, then it's not an MFAT-driven piece of legislation.
Or just more of a specific role, someone that is within MFAT. Because we're talking
I
about
think
climate change.
Bruce might have an answer for that.
Yeah, there is. There's a Maori policy unit, and if you look at the terms of reference, operationalising the Climate Mobility Action Plan, you'll see that it's very heavily based on te tiriti obligations. Quite frankly, it's impossible for me to conceive of a situation where we're beginning to have discussions around mobility that don't involve lived experiences of Maori people in terms of their own mobility in a post-colonial situation. So it's front and centre of the work that I do, and there's a specific unit. I don't think I can give out that person's name.
I don't need to
For sure, there is a Maori policy unit, and we're heavily engaged with it, as well as partners at MPP and things of that nature. So yes, there is.
Thank you.
Thank you very much indeed, Bruce, and thank you, Emmeline, as well. So we've got two more questions that I absolutely will have to call it to a close, unfortunately. So Alberto and then Gay, please. Thank you.
Thank you, Juliet. A question for Arun. So how do you think that the war in Ukraine will affect the climate change negotiations?
Well, we didn't see much disruption from the war at the recent subsidiary body meetings in June. There were some strong statements delivered at the start, but then we got on with our business, and that's exactly what happened at the annual Antarctic Treaty meeting in May as well. So I hope we can find a way to obviously hold Russia to account for the terrible things it's done, while also not letting our work slip. The effects on international flows, we've already seen that the European Union has agreed not to import as much any Russian fossil fuels. I just don't know what effects that will have on the global demand for those products. But as far as the negotiations go, so far we've managed to find a balance.
Thank you, Alberto.
The invasion is sending huge ripples through energy markets and through European climate and energy policy. Yeah. They go on about it, but and they pull different directions. You know, from a European power company's point of view, it is, oh, we'll keep the coal plants open for another few years. But at the same time, it is, well, shouldn't we be focusing more on energy efficiency measures? So, you know, it's real turmoil. World oil prices are high. Russia can still manage to sell its oil at discounted prices. They're doing quite well out of it. But it's a lot going on. Yeah. Not all of it very satisfactory in terms of energy and climate results.
Thank you.
Thank you. Gay, last but not least.
Hopefully. Just in regard to climate mobility and things like that, is there any treaty work going on or under consideration about if people in the Pacific do lose their physical territory and it becomes uninhabitable and they have to move? Is there any work going on about ways to preserve their nationhood or sovereignty? What's going on in that space?
Yes, New Zealand has supported a declaration on preserving maritime zones within the, I think it's the Pacific Islands Forum, so that as sea levels rise and atolls that would normally give rights for maritime boundaries engulfed, that there will be further work done to preserve those zones, at least amongst Pacific Islands Forum members.
Yeah.
But in the climate space, less so.
But what about preserving the maritime zones, but what about the people themselves, preserving their communityhood or nationhood?
Yeah, there's definitely work being done on it, but I'm not across it, I'm afraid.
Yeah, there is work, and it sounds like our participant online can help us with it. But you know, migration with dignity or
yes, Bruce can.
has been a big part of the thinking. There has been quite a lot of talk about climate refugees. It's got a good sound to it, but actually, Pacific people say they don't want to be regarded as refugees. Thank you very much. And it doesn't really fit the definitions, accepted definitions of refugee status. So migration paths is going to be what we're looking at.
And preserving nationhood is something like that.
Bruce, did you want to jump in if you had a point on that? Bruce, you're on mute.
So I don't work for MFAT, so I'm not speaking for MFAT, but I can certainly say that they're a watching brief across the issue of statehood and the implications for statehood. I sit on an international law committee that's intersecting with the International Law Commission's work on this space, and we drafted something called the Sydney Declaration, which was picked up and now is in the work program with the International Law Commission. So there is an ongoing program of work around what sea level rise might mean, if anything, for statehood. But my view on that the discussion is a bit overblown. I mean, if you actually look at the way in which states have responded to changes in any of the indicators of statehood, the classically accepted ones, they're pragmatic. And I think that Tuvalu made a very interesting argument, for example, I think at the last General Assembly, that, you know, the international law regime around the 1933 convention, the Montevideo Convention, talks about state formation. It says absolutely nothing around state extinction. And so there's that issue to consider. There's some really interesting arguments being made by the International Law Commission, which I think can be developed quite further. But I think ultimately, it's going to be dealt with in the realm of politics, not international law. I think there's a place for international law to try and sharpen and focus some of the debates, but ultimately I think it's going to be settled in the realm of international politics and not international law. But certainly I know there's MFAT have got to watch your eye on these developments, so I can't comment on what they're actually doing in-house.
Thank you very much indeed, Bruce. That's great. I think we should thank our speakers very much indeed for a fabulous session, and we need to go and have a wee break. So thank you very much indeed. Tea break, coffee break, comfort break. So we'll come back 15 minutes, so past onto our final speaker, who will also be fabulous, I'm sure. Thank you very much.
I get in some classes that it would
Welcome back, everybody. We are now on to our final guest speaker, who is going to be equally as fabulous as the former guest speakers as well. And this gentleman is Dr. Robert Joseph. And Dr. Joseph has tribal affiliations in the East and West Coasts. And he is an associate professor at the Piringa Faculty of Law at the University of Waikato. He is the current director of the Maori and Indigenous Governance Centre at Waikato University. And he is also the current founding member of Te Taumata in the Ministry for Foreign Affairs and Trade, dealing with Maori interest, Treaty of Waitangi, and international free trade policy laws and agreements. And Dr. Joseph was a Claude McCarthy and Fulbright scholar, the latter at Harvard University, and why at a university you would have known that. And he is a representative on a number of international consortia, including the International Intertribal Trade and Investment Organization and the International Indigenous Governance Consortium. So, without further ado, yes.
Tēnā no tātou, aroha mai. I'm lucky last, but I'm conscious that our numbers have dropped. This is the graveyard shift. You're tired, I'm tired. So I'll try and do this in some good time. I'm looking at Maori, the Treaty of Waitangi and free trade agreements. It's kind of following along on our theme about international law, some important developments in the space, but then going into the whole Maori area. As Juliet mentioned, I am a member of the Taumata, which is a new committee with the Ministry of Foreign Affairs and Trade. I think it's quite an important committee too, and I'll talk about that a bit later on. I do have a PowerPoint. I kind of suspected
you need it here.
To keep you going. So I've got a number of pictures. I'll try and keep this to 15, 20 minutes too. And then I'll be open to questions. So, yeah, so these, all of these diagrams I have, that's to help us learn and help us stay awake. And when you're sharing about Maori, I think a picture paints 1,000 words. So bear with me. So first on, I'll talk about the origin of Maori. It's important in our context today because the origin of Maori, there's different schools of thought. Some say they come from the east, from China. Taiwan, I have spent some time with Indigenous peoples in Taiwan and they claim we come from there. Others say, other school of thought, we come from the west up in the Americas. We do have strong relationships with the Eastern Pacific. What's important about these origins, whichever school of thought we advocate, that Maori were great seafarers, great navigators, sometimes referred to as the Vikings of the Pacific. Right? And they were navigating the biggest body of water in the world, i.e. Te Mana Nui Akiwa, or the Pacific Ocean, depending on which school of thought again, during the time of the Vikings, and where other European nations were afraid to go out of sight of land. But they had not, waka doesn't quite capture it. A canoe wasn't a canoe, waka were ships. You couldn't row across the Pacific, right? So they had these big waka. And what they used to do on this international travels, a lot of the things from our oral accounts is they were trading. They were engaging a lot of trade. Yes, they were warring to, get conflict. And in fact, a lot of wars over trade. Right? So they were doing that and other things. But contrary to what some anthropologists say, they accidentally came here, not so. They were avid navigators. They were great seafarers and also great international traders. Historically and traditionally so, Māori were great risk takers, innovators, and entrepreneurs. Right? historically, and other Indigenous peoples, I might add. Now, just need to switch quickly to how did they engage in trade? What were their laws, their legal system? It was based on tikanga Maori. I'll show it real quickly. I don't have time to get deeply into this. I'll just say this, tikanga Maori, Maori customary law is similar to international law, public international law. I say that in a number of respects. One, it was based on custom, accepted practice, or tikanga. Two, also on kawinata, or agreements, or treaties. And there's a third area which is similar to use kogans, which is these inherent wrongs. Māori had that notion as well. Right? So tikanga Māori was similar to international law in those respects. I just want to highlight though in the Māori world, tikanga Māori is relational, not transactional. It's based on relationships and rights and responsibilities associated in those relationships. I think in similar ways, international law has some similarities. It was also, and I'm assuming you understand tikanga law, as a legal system, tikanga Māori is always also values-based, not rules-based. Right? We have these key values. Contrary to legal positivism, tikanga Māori is a legal system that's relational and strong emphasis on morality. Tikanga means doing what's right, just, correct, or appropriate. So there's an inherent morality in tikanga. So it's relational, it's values-based, not rules-based. Now with that background or foundation, with settler contact, first in 1642, the Dutch footprint was light. The English was a lot stronger in 1769, but almost immediately after Captain Cook came here, there was a lot of commerce going on, a lot of trade going on, not first internally, but also internationally. And the first trade items, well, the main trade items internationally in New Zealand, well, from Aotearoa, that Māori were engaging strongly in too, by the way, with whaling and seals. Then timber, then the flax trade and other commodities. And Māori were key players in that too. Unfortunately, there were some seedy areas of international trade historically too, such as the sale in human trafficking, to be frank, slavery, Māori heads, moko mokai, prostitution, and these other challenging areas such as alcohol, tobacco, sugar, and other addictive substances, which unfortunately Māori are still grappling with today, as are others. But Māori were engaged in this, and it's my, thesis. They were starting to shift and go contrary to the tikanga there. But all this trade going on, Māori were engaging in it. In 1835, they signed a Declaration of Independence, the Whakaputanga o te Rangatiratanga o New Tireni, or the Declaration of Independence. They signed this with the British. You don't know what the impetus from the Māori perspective was for this declaration? Okay, it was trade. International trade was the impetus for this for Māori. What happened really briefly, 1830, some Māori ships with their goods were impounded in Poihakina, which is Sydney Harbour, Port Jackson. The old name, the Poihakina, their goods were shipped up there for international trade, and they were impounded for breaching maritime law and international law. They weren't a recognised nation, they didn't have a flag on their ships, so they're impounded, which was a slight in the mana, or slight to the mana of the chiefs at the time. As a result of that, they came back here, discussed with the British resident, James Busby, we need a declaration so we can be so we can trade internationally without any barriers, without any obstacles. Incidentally, they had a flag debate at the time and chose that flag up at the top, a very British flag. They acknowledged in 1835, Great Britain was the strongest nation. They ruled the waves. So they wanted to go under or with them to assist them for the international trade. So I share this with you just to highlight that Māori were engaged very strongly in international trade historically. In some ways, we're even controlling international trade and the economy. Yep. Now, the Treaty of Waitangi carried on their position, amongst other things, depending on what your view is on the translations and so on. I'll just say this, one thing that they did want guaranteed from a Māori perspective in terms of consensus ad idem was prosperity, was carrying on with their trade and their economic development. And after the treaty, we entered a period what Māori refer to as whairawa, or the golden age of Māori development. Māori engaging a lot stronger in international trade and also national trade, for that matter. And the kingitanga Potato at the top there, one of the reasons he was asked to be the king in this area was because of the amazing economic prosperity in this area, as well as a few other cultural considerations as whakapapa, having what we call mana whakaheke, his ascribed mana from his genealogy, but also his mana whakatipu, or his achieved mana from what he'd done in life. Prosperity, his prowess in war, and a number of other things. That's why he was selected to be, or nominated to be the king. Waikato Tainu, I'll now focus in this area. There was a lot of prosperity in this area, a lot of international trade going on. Māori had their own schooners, flour mills, their own newspapers, and even here they had their own bank. Again, a lot of this is not well known, but it is factual. And just to provide a real quick example, it's 8 minutes so far, so I'm halfway there. The gentleman on your left is Wani Papita from Taumamutu area, from Ngāti Apakura, and Governor Gray on the right, Governor George Gray. In 1849, so Governor Gray came in 1846 to 1852. There was a lot of economic development going on here. This area is known as the granary of the North Island. Farming, orchards, wheat, and Huani Papita out at Rangiaowhia, just outside of Te Awamutu, they built 3 flour mills in their village. And then the first flour that they'd ground from their wheat, so Governor Gray came and visited them. They gifted it to Governor Gray as a gift to give to Queen Victoria. Oh, I forgot to mention too, the Declaration of Independence and the treaty in the Maori world, they are agreements or kawanata, covenant agreements, and similar to Judaism, a kawanata in the Maori world is a binding agreement between parties. What happened here was they sent their first fruits up to Queen Victoria in 1849, have all that correspondence by Governor Gray. Queen Victoria was startled by it. In the Colonial Office, they were startled by this too, but she reciprocated by sending 2 of these paintings to Ngāti Apakura. They were very prosperous. They had 3 churches, a Catholic church, an Anglican church, and a Maori hahi. But these portraits of the royal family hung in the churches. Now, to Maori, for Ngāti Apakura specifically, that was a kawanata, a covenant or agreement between Ngāti Apakura and the British monarch, Queen Victoria, specifically at a tribal level. The treaty was at a pan-Māori level, national level. And so you had all this trade going on. There's just some of the statistics. So Māori were shipping all their goods up the Waikato River, the Waipa River up to Auckland and elsewhere. There's some of the stats. I need to go fast. There's some more of them. They had 1854, their goods were 12,000 pounds, which in 1854 was a lot of money. They were also engaging in international trade, sending some of their goods over to Australia, to the goldfields, and also to San Francisco, to the goldfields there. And I've got a lot of information on this. So they're engaging heavily in international trade. This map The red line is the rivers, the Waikato River and the Waipa River. They were very important, a number of reasons, but economically as aqua highways for shipping their goods. The blue and the red squares are the flour mills in the Waikato from 1846 to 1861, right? Which is why this area was known as the granary of the North Island. So a lot of economic development. Māori were in effect controlling the economy. They were the biggest taxpayers and also international trade. Kawhia, as you can see there, was where they used to send their goods over to Australia, into the Pacific and elsewhere. Kawhia in the Waikato Tainu world is known. Kawhia kai, kawhia tangata. Kawhia wana, a place of great prosperity. Right? So, Māori were innovative international traders. This is what James Belich, military historian, said about them.
Also,
Where's that? There's what the late Michael King, our Waikato University historian, said about Māori. That Māori were capable and competitive entrepreneurs who could produce harvest commodities such as flax, timber on a large scale. In this context, the cooperative structure of internal tribal organisation and the system of mutual obligation implied by the custom of utu were distinct assets. Right? Close quote. So that's our great New Zealand historian. That's the Penguin History of New Zealand. That's from his book there. So what happened? Great traders controlling the economy, controlling international trade. What happened? It's interesting when you look at the Ukraine war. So the rumor was there was genocide occurring in the Ukraine. Right? Funnily enough, in a similar manner, the war in the Waikato was generated by a rumor that the Waikato tribes were going to invade Auckland City. So before they invade Auckland City, we better invade them. And that's what happened, interestingly led by Governor Grey. So he breached a lot of the tikanga, Governor Grey. He could call it a Māori too, actually. And worked a lot for Māori. So there were these wars going on. Only thing I'll say is most wars are over two things when you boil it down: sovereignty and property. Right? I'm almost guaranteed that's what the Ukraine's about to. But anyway, so that happened, and that's colonialism. Colonialism where you're displaced from the sites of power. That's what happened to Māori in the economy, law, the environment, international trade too. So from this period, prosperity, Māori were now legally, institutionally locked out of international trade. Okay. Fast forward to today, we have these treaty settlements going on, which are about, among other things, rectifying the past and these breaches of the treaty, historic and contemporary breaches. Approximately 80 have been signed to date. Depending who you're talking to, it's highly political. We're possibly halfway there, according to some Māori. So of all these treaty settlements going on, there's a lot of economic development being resurrected and so on, and international trade. Māori are engaging again in this space. You have the Treaty of Waitangi Principles. You know all about these 3 Ps: partnership, protection, participation. I would like to add a 4th P: shared prosperity too. It's not just procedural, it's outcome focused too. Like Māori had when they signed the treaty and they were controlling international trade and the economy. But as a result of treaty settlements and Māori land trusts and incorporations of other Māori corporates, like today, there are over 10,000 Māori corporate organizations engaging in economic development in some shape or form. A number of them are engaging in international trade too. So that today, the latest statistics, there's a growing Māori economy. The Māori control 50% of fisheries. That's commercial fisheries. 40% of forestry, 30% of lamb production, 30% of sheep and beef, 10% of kiwi fruit, and 10% of dairy. Right? Challenge in this area, like it was historically, it's primary sector focus. They are diversifying into other areas. Energy, infrastructure, social procurement, telecommunications, IP, intellectual property, and other areas. Right? So Māori are investing overseas. One of their biggest partners was China. And as I mentioned earlier, tikanga Māori, our Māori legal system is relational and values-based. International trade is relational. From a Māori perspective, relational and values-based. What are our shared values to enter into a relationship? Once we have trust, right, never mind the transaction, the relationship's fundamental first. And once that's set, now let's talk business. And I understand that's how Māori commercial fisheries got the partnership with Nisui. They're partners for the commercial fishing, Te Ohu Kaimwana, where other New Zealanders were trying to engage in a lot of business and trade with the Japanese. It was a lot faster with Māori and other Asian nations because similar values, similar customs, and so on. Anyway, so fast forward to today, a lot of international trade going on, Māori are engaging in it. And the Māori economy currently valued at, 5 more minutes, currently valued at 70 billion. So a lot of economic development going on and trade. So as part of this, remember I mentioned Māori were locked out of the international trade sector. Now we're getting back into it. And what MFAT did in 2019 was they established Te Taumata. It's a treaty partnership between Ministry of Foreign Affairs and Trade and this Māori committee. I just happened to be at the final national hui at the time and was nominated onto this. It was all accidental. And I've been there ever since, and my wife's whinging about the time I put into this. But it is an important forum. So this taumata is about a treaty partnership in the private sector in the international trade space. We have a lot more women on it now too, by the way. 3 women now. But those are the nominations. There were a number of hui that were held. The final hui they asked for nominations for this committee. But this committee actually assists MFAT with the treaty obligations, with free trade agreements, policy, relationships, and so on. The world is changing in international trade space due to COVID, some things, and politics of protectionism. So trying to make the playing field with FTAs a bit more equitable, particularly in terms of labour, SMEs, right place of women, human rights, the environment, sustainability, climate change, and also Indigenous communities. And Now, us specifically in New Zealand, we've already talked about the UK and New Zealand Free Trade Agreement and also the European Union Free Trade Agreement. Our taumata, we have this whakatauki, right? If you're not at the tables of power, you're on the menu. In the past, Māori have been on the menu. Now our taumata is actually sitting at these tables of power. When they were negotiating these free trade agreements, we were contributing directly to the FTAs. I have to confess, we had to fight tooth and nail to include, and we got it, an Indigenous chapter in both FTAs. A lot of politicking going on. I specifically went through with the UK ambassador and other leaders there to remind them of the Declaration of Independence, the treaty, this agreement, or this kawenata with Ngāti Apakura and these other developments that happened historically here, which cemented, from a Māori perspective anyway, this kawenata, this relationship between Māori and the British Crown. And so we had some responsibilities and obligations that were ongoing. They finally relented with some politicians coming in. And I have to say this, in the 11th hour, 59th minute, we did get an Indigenous chapter included in both. In fact, the European Union one signed about 3 weeks ago. The European Union ambassador came and spoke at a symposium we ran here. And she actually mentioned that the role of our taumata was important in helping her understand what Māori wanted and also aligning our Māori values with some of the important European values. Right? And when you have a look at it, some of the wins, the farmers are grumbling, includes the Māori farmers too, and they said the European farmers are grumbling, but it's been really good for a lot of Māori corporates in the commercial fisheries space, kiwi fruit, other fruit and vegetables area. and Manukahu, amongst others. So we've been sitting at the table. We're also sitting with these other free trade agreements that have currently been negotiated. I have some booklets here which describe all of these that our taumata has commissioned. If anyone's interested, you can come and get some of these from me. I'll also just say this and finish off here. I'm the New Zealand representative on this organisation, the International Intertribal Trade and Investment Organisation. Some of you might recognise the gentleman at the end on the right here, our former dean. On this organisation and others, what we're trying to do is facilitate Indigenous trade and direct Indigenous to Indigenous trade, right? And our free trade agreements, but also directly to, as we did historically, right? Trying to resurrect some of these old relationships. We're getting there too, starting with some of the casinos in Oklahoma on their reserve, getting some of our Maori commercial fishing, just working really almost there on that. So from a Maori perspective, when we look at international trade, our view is it's commerce through culture, finance through whakapapa, and trade through tradition. So we've entered into a free trade agreement with the Indigenous peoples in Taiwan, 2020 within Australia with Aborigines, and trying to do a few more. But we're not locked out of the international trade space anymore. We're gaining more momentum there. And so my presentation conclusion, more moody mamua. We're going back to the future. Kia ora tātou. Sorry, I went over time.
No, that was great. That was so fascinating. Thank you, Robert. So, we've got time for questions. As ever, I will monitor chat and wave out there, whatever. But first and foremost, we've got Emmeline. Thank you.
This is a very important question. So, sorry about the comment that I said about James Belch being man. I'm a bit of a super fan of him. And so, anyway, my question is, in relation to this never-ending debate, could New Zealand become an independent country? Do you think in relation to how we have progressed and even Māori have progressed in relation to international trade, that won't be in our best interest? What's your view?
The short answer is not in our best interest. I don't think any country is really independent in terms of classic sovereignty. That's what free trade agreements are about. You're surrendering some of your sovereignty and independence for your vital interests. So we're not, maybe Russian would be proclaiming they're totally independent, but even then, I don't think it would be good.
I agree. After seeing your presentation, there's too much progress.
So can I have a copy of the slides?
Yes.
And do you mind if I pitch some of that information?
Yeah, sure. I was hoping the pictures would keep you awake.
My question though is, if Māori are involved in some of these free trade agreements, how do Māori business engage with Te Taumata? I mean, is it something you do as a general thing, or is it something that each Māori business can approach you for?
Yeah. Actually, that's a good question. How do Māori businesses engage with Te Taumata? First thing I'll say is the Taumata is one committee that is, trying to champion Māori interests in the space. There are others, so we're not the only one. But in terms of us engaging with Māori businesses and Māori generally, what we've held over the last 2.5 years is we bring MFAT and the ministers of trade and other key players to Māori communities. And that's what we did 3 weeks ago. We had this symposium here, and we've done it in Rotorua, down in Nelson, Gisborne, up in Pai here. We're bringing them to our Māori communities, and it's an opportunity for our Māori to come and talk with them, to find out what's happening in the space, what's beneficial for them, to challenge, to engage, and so on and so forth. That's one of our best ways of trying to be accountable to our people. Also, through social media. We have a website online, trying to send out all our information to our Māori corporates. We do have a database, thousands, I forget how much, but a lot of our Māori businesses. who are working in this space. We have them on our database and send them all our newsletters, so on and so forth. But it's not easy being accountable to the Māori community, let alone any community for that matter. But we're trying to in that space.
Robert,
Yes.
I just wonder if you
Sure.
could, sort of rounding that out, if you could just say a few words about the trade deals that have been done between the UK and individual Maori corporates in the lead up to the free trade agreement, because there's been quite a lot of action in that space over the past 2-3 years.
Yes, there was a lot of action. The British High Commission actually was attending all of our regional symposia, our regional meetings. She was there and hosted dinners the night before it started. Taumata and Māori corporates were invited there and engaging directly with those. She spent a lot of time with them. And we were, sort of championing a lot of our corporations' interests directly with them too, as well as with the European Union ambassador and leaders. And also like at our regional meetings, they're usually 1 or 2 days. The first half is the government MFAT presents and minister and so on. The second half is the local Māori corporates present to give them an idea of we're in this space and we need to work with you. Right? How can we, benefit best from these free trade agreements? And so there's a lot of activity, proactive activity going on from the Māori corporates with our taumata and some of these other committees working in these particular areas, such as Professor Jane Kelsey, who's online. She's involved in one of the other Māori committees and others to proactively assist Māori corporates in the space. Can I answer your question, Trevor?
And I just thought it was good just to get some of the other background out there.
Yeah. So it's been very proactive, a lot of work, a lot of resources going into this.
Thank you very much. We've got a question from Anne up on the Zoom screen. Anne.
Kia ora. So I'm Anne Hertog and I'm from the University of Auckland. So I hear a lot on what you're saying about getting the advantages of the FTAs out to Maori businesses, but a key effect of the FTAs is their effect on regulatory autonomy and the restrictions that they bring for states when they sign up to these. And I wonder, what input have you had in the development of these rules? And do you think that these new Indigenous chapters provide enough protection so that we do retain space within New Zealand to regulate it for Maori interests in a way that Maori want?
Yeah. So we were pushing strong for Maori interests and it's more substantive. However, some of the results of the Indigenous chapter, for example, for the European Union, I mentioned that commercial fisheries are gaining access into the European Union from day one when it is implemented and with no tariffs. And as I mentioned earlier, Maori corporates control 50% of that industry. And so for Maori corporates, that's a big win. Not the Maori farmers, same with the New Zealand general farmers. Those are big challenges, but we were focusing in those areas, more substantive sort of implications or substantive areas of the FTA and the importance of the treaty, the importance of the historic relationship and future relationship and what this means in terms of actual benefits for Māori communities. I'll just say this too, in New Zealand, 1 in 4 jobs in New Zealand are dependent on international trade. That's a very important area for our country.
Thank you.
Yeah, maybe we could carry on a discussion later via email or something.
So we've got a few more questions or a few more people that want to ask questions. So next up is Tane. I hope I've pronounced your name correctly there, Tane.
Pane.
Kia ora e ohoa. Thank you very much for your presentation. Full disclosure, I work at the Ministry of Foreign Affairs and Trade in the Trade and Economic Group. Noting the significant increase in activity from Māori on international trade matters in recent years, Taumata established in 2019, I wonder if you might cast your vision forward 10, 15, 20 years from now, and tell us what you see, what that looks like.
That's $1 million question, that, Tani.
What would you like to see?
Yeah. Okay, can I just start answering it by whakatauki by King Tāwhiao. After they lost everything in the war, their lands were confiscated, they were pauperized and so on. His guiding whakatauki for Tainui going forward was e kareko whakakitenga. E kareko ana he whakakitenga kia mate te iwi. Where there is no vision, the people perish. Right? They needed a shared vision. Right? Under the support of the kingitanga carried them forward, which led to the treaty settlement and all the economic development going on now. So it was intergenerational. I think in a similar respect, we need a cohesive vision for our people, our communities, and then the corporates going forward, not the other way around. I have to disclose some the challenges going on with the Māori economy as our tribal corporates are becoming billionaires, but our tribal communities are still poor health, poor housing, undereducated, and so on and so forth. So there's a disconnect there. So they need to be directed by the communities rather than the corporates. And with our Māori governance sort of vision and economic development, international trade going forward, it has to incorporate within that vision what I call bear with me here, the 4 T's of Māori governance. Has to incorporate traditional, transactional, transcendental, and transformational governance. Currently, it's focusing on transactional. It has to incorporate those other 3 as well. Right? Traditional, transactional, transcendental, and transformational. Coming back more specifically to your question, I think in 10 years' time, Māori are going to be key players in international trade again. 10, 20 years, if we carry on this, this trend, as it were, with our free trade agreements supporting Māori development more, Māori in the trade space. From my experience working overseas too, I have to admit, being Māori is an advantage, an advantage for us here, and I'll maintain that at an institutional, national level too, in terms of what's important to us, our values and relationships, then transactions, right? Including many of these issues we've discussed today about climate change. Māori subscribe to this, to those values, the importance of the environment, kaitiakitawa, and so on. So I'm hoping, in answer to your question, Tāne Māori be bigger players in the international trade area, but also their communities are significantly improving with that economic growth too. That's going to be the challenge.
Thank you very much. We've got, I think, time for just 2 more questions. So we've got Dara and we've got Alberto. Oh, Lars, we'll fit you in a 3rd one as well in that case, as long as it's quick.
So I'm all for free trade agreements. I see them as a way for not just only Māori, but for all communities to improve their places and spaces. But the thing about Māori in particular that worries me about these free trade agreements is that they're revolving doors. They're two-way street. How do Māori protect their taonga? How do we protect that here? Because, it's all very well for us to say, let's engage in international trade. And I agree with you, Māori were big traders. I can remember my grandparents talking about this years ago. but they were trading in Sydney. They were trading outside of New Zealand and protecting, you know, their whenua. How do we protect that taonga from all of these free trade agreements?
Might be better you talk with Professor Kelsey about that one. Yeah, we've got to protect our taonga, I suppose. With free trade agreements, some might say we could be vulnerable to the whole international space going on, dependent on these rules functioning, or be it soft law. But in terms of specific protections of Māori taonga, in terms of intellectual property,
PVR, all of those.
yeah, all those things. I don't know if you're aware of the big dispute going on as we speak on IP around Manukahani. Our Manukahani is much sought after internationally for its medicinal properties, right? And it's worth a lot of money. I've seen it in the airports and overseas and almost fell over about how much it costs. But there's a big debate going on with Australian corporates trying to claim they have Manuka as well, and they're using that label, Manuka. We're trying to, well, the trust that's leading some in our taumata, they've been taking them to task about it and saying that's a Maori word, not an Australian word. You know, there's all that debate. It's going on, but that's what this report's about. Geographic indicators and Māori interests and IP. So if anyone wants that, I can give that to you. But the free trade agreements, and there we've been negotiating the importance of geographic indicators and IP. You know, that's important there. And in the European Union, FTA, it includes Manukahani, protection of it and getting access into the European Union with no tariffs. But again, yeah, it's still vulnerable though. Goods are overseas and it's hard to protect IP in the international arena. It seems to be trendy in some countries, the haka, Māori moko and different things for fashion. In Europe, some of them have been appropriating, misappropriating those, claiming ownership of them. So it's hard to protect, but hopefully in our free trade agreements we can get better protections in there for them. But yeah, it's, as you say, a two-way door going both ways. There's strengths and vulnerabilities and weaknesses.
Thank you. Alberto.
Thanks, Juliet. Thank you, Rob. So the involvement of Maori interest in trade negotiations is a recent development. What are the challenges that you think that lay ahead for this participation?
Name of the taumata specifically?
Well, could be taumata or...
Yeah, I can comment on the taumata. There's a number of challenges. One of them is we're doing this in the main, you know, out of goodwill, and it's quite exhausting. It's taking a lot of time and energy from us, and we're, yeah, it is out of goodwill, or do get paid for meetings we attend, but it's quite minimal with respect to MFAT. I think that's a government issue, that. Yeah, as I mentioned, my wife kind of complaining about me being on this committee, saying, in effect, they're getting $1 million advice for peanuts in the work we're doing. So, you know, there's that challenge and the challenge of burnout for us. I'm involved in too many things, and my teaching here too, of course. But, you know, a lot of tribal matters, and our kids, and other committees I'm on, which is important for PBRF, by the way. Justification in some ways, but yeah, and so there's those challenges about resourcing. The challenge, another challenge for us as a taumata is some of these other competing committees. But we have to take our hat off to the leadership in Ministry of Foreign Affairs and Trade, particularly Vangelis. He's a great ambassador for New Zealand and international trade, our interests, but also support for Māori in this space too. So we've got a key leader within MFAT who's supporting us, but in that respect, what happens if he leaves? Right? So there's those challenges for us as te taumata. numerous others, funding, competing interests. I mentioned earlier how we were nominated at a national hui. Now we're trying to formalise processes more and institutionalise them more. We have a constitution and all these other things. And I think, I know it's subjective, but we've done quite a lot since our establishment in 2019 with these reports, mobilising our people, with our corporates, with our involvement in the FTAs and so on. And so often once you start getting some good momentum and others want to try and come in and play on that, that's a challenge of Māori governance too, by the way. And so there's those challenges and loss of institutional memory and original vision, so on and so forth. Some of the key challenges I see for us as a total.
Thanks a lot.
Thank you. And we will finish with a question from Lars. Thank you.
Yeah, I was thinking about the disparity between the Māori corporates and the Māori community. I mean, it seems strange to me that a lot of the fishing industries that say 50% owned by Māori, I mean, but they end up employing a lot of people from overseas and they're unable to, but for some reason they don't employ the local yet, 50% of prisoners are Māori, you would have thought there would be a good pathway for a lot of people in prisons, but is there problems with like the ownership, do iwi have control, ultimately do the iwis have control over this, or is it, who owns these corporates?
Māori, with the commercial fisheries settlement, which was in 1992, there were a lot of challenges over that. Commercial fisheries in Māori initially were given 10% of fishing quota. So the partnership was 90-10 ratio. And after that, in 2004, one of the challenges was who are the beneficiaries of the settlement and which corporate represents those beneficiaries. And it went to court 3 or 4 times, went to Privy Council too, actually trying to define who is an iwi, and particularly in terms of the commercial fisheries. So you had that, and then who represents those iwi interests. And so they all had to establish their own MIOs or mandated iwi organisations and a corporate entity to represent them, which is usually a company. What's happened since then was some of them weren't as astute in this industry. So what they've been doing is some of them have been leasing their quota to non-Māori corporates or to other Māori corporates. Some of them have also been aggregating the quota interests. The ICP, what does it stand for? That's a partnership, limited liability partnership, established by 15 smaller iwi with this quota so that they could pull their interests together and build some scale. So you've got that development where others have been, just leasing it to non-Māori, for profit. And so as a result of all of that, they haven't always taken on Māori or helped Māori in this industry, right? Where they're just employing who's the best one for the job. It is a challenge though. I have to say, nothing in the Māori world is simple. And, it's one thing I've been involved with trusts where we want to employ Māori. Some have been in jail and, haven't been brought up in good environment, but then trying to employ them and making sure they turn up to work and they're not drunk, all those types of issues that sort of occur too. So you have those kinds of challenges, none of it's simple. But at the same time, we're supposed to be trying to generate a profit, but acknowledging those other cultural, social issues too. So we're trying to tackle that, but I have to confess, Māori corporates at present, we're becoming too corporatized, as I alluded to earlier. And I've written a book about that actually. Now further into that in more detail. I said, sorry, I know we could go on.
That's all right. Thank you. Thank you very much indeed. I think we need
You'll
to.
see if you want any of these.
Now I shall hand over to my colleague Alberto to close our proceedings. Thank you, Alberto.
Thank you so much, Juliet. And well, just to thank you and all those present here and also those online for your attendance today. Well, I think it has been a great event in which we have learned a lot about international law and also about domestic law, the interactions between international and domestic law that is not always evident when we talk about international law issues. So I hope you have enjoyed these 3 sessions. There is a recording, so it will be available soon on the faculty's website. Thanks a lot, obviously, to our speakers from MFAT and from Piringa, and for the exceptional presentations. To you for your questions, also for those online. I've seen here our great friend Jane, Kelsey, Sir Ken Keith, and students as well, regular students of these presentations, Amy Stewart, and others. So great to see you all. And again, thank you so much.
Thank you very much.